Hello, I'm Peter Afrasiabi and I filmed this program a couple of years ago. Ethics, pro bono lawyering in the immigration system. I've reviewed it and I can confirm it is still current, so please enjoy. Hello, today's presentation is called Ethics and Pro Bono Lawyering, Looking Inside the Immigration Court System. Today we're going to discuss a variety of questions related to pro bono lawyering, looking at different dimensions to the question. For example, we will look at questions revolving around whether there should be an ethical rule that requires you as a lawyer to provide a certain amount of pro bono lawyering services to those in need in your community. And these are questions that come from the ABA and from a variety of states. We're also going to look at questions such as, if you take on a case pro bono, what are your obligations to that client? The client's not paying you, it's not like a normal client. Is there a different duty or a different set of obligations to that client? And we're going to look at most of these questions principally by looking at the immigration court system. The reason for that is that the immigration court system has hundreds of thousands of cases every year. So the massive volume of cases, most of the participants are pro se. There's a massive need for pro bono lawyers. And as it turns out, there's a large volume of civil lawyers who do go into the immigration court system and provide pro bono lawyering. In fact, for example, the Ninth Circuit Court of Appeals has a pro bono program devoted to screening and finding cases that are pro se appeals in the court, placing those cases with pro bono lawyers for oral argument. And over half the cases are immigration cases coming out of the immigration courts. In fact, the Ninth Circuit even has an immigration manual on its website that was created by the court to help lawyers involved in pro bono lawyering in the immigration arena. The other reason we're going to look at the immigration arena to assess some of these pro bono lawyering questions is that it's a particularly charged environment. It's politically charged, it's heated. People have very, very different opinions, obviously varying opinions across the full political legal spectrum about what we should be doing with our immigration policy. And so this creates a charged environment. And it's particularly interesting then to look at because, as it turns out, many of the charged environments, so to speak, the socio-political environments that provoke anxiety, angst, emotion, are environments that you often have pro bono lawyers stepping into. And so you step into this charged environment and it often raises questions as you're fighting vigorously for your client, whether you are being a zealous advocate or whether you're actually tripping your ethical obligations on that zealous advocacy line and you are engaged in misconduct. And we will look at that by looking at some disqualification type questions. And so the immigration system in that sense is a fantastic petri dish because it's a lot like, for example, the detainees at Guantanamo Bay. Most of them were represented by pro bono lawyers from different civil rights organizations. Again, another charged type issue. So as we turn to the first slide, we're going to principally look at what we have here, the two ethics dimensions arising from pro bono lawyering. The first one we're going to look at comes from the Cold War, and we're going to start by looking at the longest and most bitter deportation battle in American history. It was a 20-year campaign spanning 4 serial cases brought by the United States government against labor leader Harry Bridges. He was a radical labor leader from San Francisco who rose to prominence in the 1930s and spent then 2 decades in deportation proceedings. And because this was an immigration deportation battle, it was very charged. At the time, he was alleged to be a member of the Communist Party, and we were in the Red Scare, and so it was an environment of great social anxiety. This funneled into the litigation, and his lawyers were essentially pro bono lawyers from a variety of different organizations who had been brought to represent him. And it gives us a fantastic petri dish to then look at a charged system where you have lawyers engaged in zealous advocacy or perhaps challenging the supremacy of a judge too much and tripping their ethical obligations and engaging in advocacy misconduct. We will then shift from there and we will broaden the lens and look at the current immigration system, and we will assess some of the ethics questions that then relate to pro bono lawyering, the obligation to do pro bono lawyering, and what happens in our current immigration system and how that system differs somewhat to our normal court system and some of the ethics questions that triggers in terms of pro bono lawyering. So let's get started. You can see on the next slide, we're going to start with the Harry Bridges deportation saga and the questions of judicial disqualification. The stage is the Great Depression, 1934, San Francisco. There's massive social economic upheaval. It was a time of obviously mass unemployment, massive anxiety, fear of potentially a communist revolution. And you had some of the national labor laws were then enacted and were coming to pass to try to bring some order to this labor system. And on the Embarcadero, specifically where Harry Bridges was, there was massive problems. You had Harry Bridges, who was a longshoreman, and you had sort of a sham union that was really controlled by the ship owners and the Employers Association. And the men on the waterfront at the time worked in terrible working conditions. There was no minimum wage, no insurance, no health care. They were forced to work even when injured. They were forced to pay bribes and kickbacks to get a day's work. And so it was sort of this environment of heated passions and problems. And it boiled over in 1934 as Harry Bridges, who was just a longshoreman, started speaking, and he had come from Australia, and he started speaking loudly about the need for change and the need to have a real union. And as his sort of Australian voice started speaking loudly about the need to change what was happening in America, it turned out that a lot of the men on the front lines, the longshoremen, started following him and started agreeing with him. And so he built this small little faction within this sham union. And eventually, as things came to a head, he called for a strike, and the union officials, so to speak, disagreed. But he stood firm and defiant and demanded a strike. There was a vote taken, and it turned out the longshoremen voted with Harry Bridges to strike. And so this began the Great Strike of 1934, which at the time was the longest strike in West Coast history. It shut down all the ports on the West Coast for almost 3 months. And in the middle of that strike, you had an event where the ship owners tried to bring in some strikebreakers, and a fascinating footnote to history, the strikebreakers were USC and UCLA football players. And this is during the summer, and it was their summer break from college, and so they brought up the football folks from USC and UCLA to come and be strikebreakers. In any event, that provoked melee on the waterfront, and the protesting longshoremen blocked them. The police were called in, the police opened fire, and a little war basically erupted on the streets of San Francisco where 2 men were killed. Over 400 or 500 people were shot by police. They were wounded with shots to the back. And out of this then, massive social change occurred because the federal government got involved. They called in the governor called in the National Guard. And this then brought Harry Bridges to prominence on the waterfront. And the result of all this was ultimately a mediated resolution with Harry Bridges at the helm of a union. And so immediately cries went up that he was a member of the Communist Party, and they wanted to begin deportation proceedings against him. And so this begins his 20-year saga. And as he was then placed into deportation proceedings, he immediately needed lawyers and didn't have resources. And so the lawyers were effectively pro bono lawyers who eventually received some small money and costs from legal defense funds that were raised, but they were principally pro bono lawyers who were brought in to represent someone accused of being a member of the Communist Party and asked to defend him. And it was a very charged environment. The first trial had witnesses who testified that Harry Bridges was a member of the Communist Party. On cross-examination, many of the witnesses were shown to have been perjuring themselves. They had been bribed by government and private officials to frame Harry Bridges. And this was the first public immigration trial in American history. It was at Angel Island off the coast of San Francisco, open to the public. It was the celebrity trial of the day, so to speak, up there. And Harry Bridges ultimately prevailed. The dean of the Harvard Law School was a trial examiner, and he concluded that no, Harry Bridges was not a member of the Communist Party. The day after he came to that decision, Congress literally passed or began impeachment or began proceedings to pass a bill of attainder in order to deport Harry Bridges, notwithstanding that trial verdict. And this then provoked changes in immigration laws, and he was then placed into a new deportation proceeding, which ultimately, with a hand-picked judge from the Attorney General, resulted in his order of deportation. He took his case all the way through the federal courts and convinced the Supreme Court to take the case, and by one vote, he won. The Supreme Court found the case was an outrage, in effect, and the lasting quote from Justice Murphy is that it was a testament to man's intolerance to man. And so Harry Bridges was then free. But it didn't turn out that was the case, because he swore in as a citizen, and the oath to swear was to swear you're not a member of the Communist Party. He swore, and the United States government, through the Department of Justice, then instituted a perjury criminal case against him and a denaturalization case, claiming that when he swore that oath, he lied because he really had been a member of the Communist Party all this time. And so this then provoked, in 1950 now, the third trial. We were at the height of the Red Scare, and this was the most charged environment yet in all of the Harry Bridges trials. And so he's brought to trial in San Francisco before a federal court, and his defense lawyer, who was effectively a pro bono lawyer, was a man by the name of Vince Hallinan, a famed trial lawyer of the day, a real slugger. An Irish Catholic boxer by background, became a lawyer, and was just sort of a very famous street brawling trial lawyer in San Francisco. Did a lot of celebrity cases and the like. And so you can see on the next slide, this is the quote obviously from Justice Murphy that we talked about. But what you had then is this situation between the federal judge, Judge Harris, and Vince Hallinan. And they'd had a prior relationship. And this starts getting us to questions of zealous advocacy and when one goes too far. And so the background to their relationship, which was an acrimonious relationship, allegedly, was that Vince Hallinan had had a prior run-in, so to speak, with Judge Harris. What had happened was as follows. Before Judge Harris was a federal judge, he was a state judge. And at the time, Vince Hallinan had a legal dispute with a guy named Eugene. And basically, Eugene sued Hallinan and said, "You owe me $10,000. Hallinan said, "No, I don't." And there was a dispute pending in state court. And the case was not before State Judge Harris, but it was pending in state court. And at the time, Vince Hallinan alleged that Judge Harris had called him into his state chambers and had said, "Hey, Vince, you need to pay Eugene the $10,000. Vince said, "No, I'm not going to pay him the $10,000. I don't owe it." And the judge tried to pressure him to pay. He refused. The case went to trial. The judge actually turned out was a character witness for Eugene at trial. Hallinan defended the trial and received a defense verdict that he didn't owe the money. And so there had been some acrimony where Judge Harris, Hallinan alleged, had said, "I'll get you for that," and comments like that. And so that was some years before. So in any event, you fast forward, and now Judge Harris is a trial judge. And Vince Hallinan is brought in to defend Harry Bridges in this big sort of Red Scare, social anxiety environment about communists. And obviously, the history, 1950, but the Red Scare was massive in 1950. And actually, this is late 1949 when the trial begins. And so Hallinan asks Judge Harris to recuse himself. Judge Harris refuses. And so the trial begins. And out of the gate, there's massive acrimony. The government does its opening statement. They put on a case about how they're going to show a conspiracy by Harry Bridges and his witnesses who swore in for him, and how they conspired to defraud the United States government into issuing citizenship papers. And one of the charges was conspiracy. And Hallinan then gets up on his opening statement and says, there is a conspiracy here, but it's a counter-conspiracy. And I'm going to show you that there has been a conspiracy by specific government agents and private industry to frame Harry Bridges as a communist. And this has been going on now since 1934 when the first trials began. And as he started down this line of explaining what his defense theory was going to be, the government lawyers objected and said that it was an improper theory, it was inappropriate. The judge agreed and said, yes, that you can't have some conspiracy with all these people, it doesn't make any sense. And so there was this sort of battle between Hallinan and the judge over the scope of his defense theory. And so the judge told him, no, you're not going to pursue that theory, but Hallinan resisted the judge basically and continued and pushed on that theory and kept pushing on it. And he kept drawing objections and condemnation from the judge. And by the time the opening statement was done, when you read it today, it's an amazing opening statement to read because it's filled with objections and commentary from the prosecutor and the judge, who are constantly just lashing Hallinan for going too far. And so then the government puts on its first witness, who's sort of this, deputy who had been there when Harry Bridges swore in, and, low-level testimony really, just that, Harry Bridges swore in as a citizen and he swore that he was not a member of the Communist Party, that type of stuff. Hallinan gets up on cross-examination and starts really an assassination, showing that, you are a part of this conspiracy to paint him as a Communist Party member. He's not. You've done an investigation. He's not. And the prosecutor objects, and the judge sustains the objections and tells Vince Hallinan, you don't get to assassinate every witness that comes in here. He's a nice, mild-mannered clerk, and your behavior is improper. And so that's sort of the end of the second day. And so the third day of trial then begins, and the jury's in the jury room, and the judge takes the bench, and he's holding a thick stack of papers like this, and he proceeds to read this lengthy prepared statement, which is an order ultimately, where he orders Vince Hallinan disbarred from the court for contempt, for ignoring the judge in opening, for assassinating all the witnesses in his opening statement, for abusing in cross-examination the government's witness, and literally reads these charges and then reads the conclusion that yes, you're in criminal contempt, and orders Hallinan disbarred from the federal courts in San Francisco and orders him to prison for 6 months. And so pandemonium breaks out in the courtroom. Hallinan, the marshals descend upon Hallinan to haul him away. Hallinan holds onto the podium and he's fighting with the judge, saying, "You're biased. You've been out to get me. You said you were. I again say under penalty of perjury, I swear you're biased." And the judge tells him, "How dare you?" And so this all happens. And so what we're going to look at, as you see the next slide, is what were the ethical rules that apply here? You have this situation where the judge maybe went too far. Maybe Hallinan went too far also in terms of disobeying the court orders on the scope of his opening. And so what do we look at? And so if we look at the next slide, let's start looking at these ethics rules and standards. Principally, the rules come from the U.S. Code, 28 U.S.C. 144 and 455, which deal with disqualification of judges and when you can charge disqualification for bias. Now, we're also going to look at these California rules of professional conduct, and then the same basic rules in all jurisdictions, but the California ones are exemplary in terms of Rule 3200, 5120, 5200. And then we're going to look at these attorney conduct ethics rules that, really come from a patchwork of regimes, and you have to look at state bar rules, the ABA model rules of professional responsibility, and federal court's inherent power rules, and then even individual standing orders of judges. And what's so interesting here and so important for you as a practitioner, and this is a really important practice pointer, is the ethics rules that govern when you can charge disqualification, the lines of zealous advocacy, change by jurisdiction to jurisdiction and court to court. And you don't even necessarily always know what rule you're going to be subjected to. And this is in part because, as it turns out, we do not have a national set of standards for practice in federal court in terms of what are the ethics obligations and rules. And what's so interesting, if you pause to think about it, is that in the civil context and the criminal context, we have a national set of rules to have uniformity, so that we have the federal rules of civil procedure, the federal rules of criminal procedure, the federal rules of evidence. And if you're a practitioner in California, you can go to New York and know that the federal rules are basically the same everywhere, and you can have really similar outcomes on similar fact patterns, so that we have uniformity and certainty in the application of law to problems. We don't have that in ethics. And so what's very interesting is this means you have to be very, very careful, because you don't necessarily know exactly what rule you're going to be held to. So let's dive in a little deeper to the first rule, and that's 455 from the U.S. Code. And the major rule, as you see on this slide, that distills from section 455 is that disqualification exists for the appearance of partiality as viewed from the perspective of a reasonable, thoughtful person. And that reasonable, thoughtful person is not a judge. Now, why is this? This gets to the underlying sort of normative question about our judicial system, really. And perhaps the most defining aspect of American law is that we have the existence of neutral and detached federal courts, impartial judges. And so where you have a democratic republic that requires consent of the governed to maintain its legitimacy, we have to have judges who not only are genuinely neutral, but who appear to be neutral at all times, so that their decisions are respected and trusted and viewed as being legitimate and not the product of political corruption, for example. And so that gives birth to this rule about judges being required to disqualify themselves if there's an appearance of partiality from the facts. And so we look at this question, though, from an outward sort of factual fact pattern. In other words, we're not charging bias based on what's in the judge's heart and mind to try to get to the bottom of what's their true thinking, because as a system, we won't tolerate depositions of judges in every case to figure out what's in their heart and mind. And so we want to understand it from facts that have occurred, outside their heart and mind, so to speak, in terms of interactions with the judge. And one of the key points here, by and large, is that when you are going to charge bias and prejudice against a judge, and when a judge should be both being charged with recusal, but also recusing him or herself, those facts almost always need to come from an extrajudicial source. In other words, not from the four corners of the record being litigated. So the fact that you may not like the way a judge is ruling for you isn't a basis to say, aha, you're biased. And so there are exceptional cases where that can occur, especially in sort of the context of race and racial comments within the confines of a case. But other than that, by and large, it needs to be extrajudicial facts. As you also see, close questions, if there are close questions being litigated, we err on the side of disqualification, where the judge should disqualify him or herself. And that's, again, to maintain that policy of maintaining objectivity and maintaining a perception of legitimacy in the decision. And so this starts getting to the ethical dilemma for you as a practitioner. Do you have a sufficient factual basis to levy the charge? Because if you don't, you may trip some of those rules, such as Rule 3200, in terms of making an improper factual statement or challenging the dignity of a tribunal or a court, and trip your own ethical obligations if you pull the trigger too soon or without a proper fact pattern, so to speak. And you also have then the ethics question that you got to think about all the time, and that's the blowback, right? If you charge ethics when you perhaps shouldn't, or it's a wobbler of a case, and the disqualification bid is denied, what could happen to your client and your case that you're continuing to litigate before that same judge now that you've made that charge against the judge? And these are very delicate decisions that you have to weigh based on your wisdom in your case. So as we move forward, we take a look quickly at these California rules that are exemplary. For example, 5120 says no extrajudicial statements that will have a substantial likelihood of materially prejudicing a proceeding. 5200, you shall not seek to mislead the judge or jury by a false statement of fact. And 3200, you can't assert a position without probable cause and for the purpose of harassing or injuring any person. And that would include harassing or injuring a judge by making a false ethics charge. So none of them perfectly engraft onto the bias situation. And so this is one of the complexities, is that each of the rules bites at making that ethics disqualification charge against a judge. And you have to be very, very careful and tread very, very carefully here. And so I think all of them, and these are very, very similar in all jurisdictions, distill into one simple cautionary proposition for you as a practitioner. And that is, when thinking about disqualification, speak very carefully and speak very honestly, and don't ever charge disqualification lightly. It's sort of that last resort charge where you have something. Suspicions aren't enough. Now, the flip side, of course, is what are the ethical standards that govern the judge who's hearing the case? And here we have the Code of Conduct of United States judges, and they're the same basic canons in the state courts. But this is Canon 2A for federal judges. And it is to act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary, and also to avoid impropriety and the appearance of impropriety in all activities. So this then takes us to the next slide, where we get to our issues. The dilemma for you as a practitioner: when do you charge it? What's that line between being a zealous advocate versus being an out-of-control lawyer? We have the dilemma for the judge: who rules on the disqualification motion, in other words, right? Who judges the judge? And then really the dilemma for everyone, the body politic and all lawyers litigating is, and state bars passing these ethics rules and the state bar attorneys is, when can reasonable observers fairly decide that someone's impartiality is in question? And so these are the major ethics questions. So let's get back to the story of Vince Hallinan and Judge Harris in the Cold War. And on the next slide, as you see, the first question we have to assess is, was it proper to charge disqualification? And so the first sub-question we ask is, were facts of a bias offered? Well, if you turn to the next slide, here we have an actual copy of the actual original transcript from 1949. It's that crinkly old paper. It's absolutely is amazing to hold and look at and see as you're going through these ancient archives. But this is a copy of the actual transcript taken in terms of the argument being made and the filings of the parties. And so what you have here is a statement being averred that Judge Harris stated, as you can see, that he was about to find Hallinan in contempt of court. Hallinan arose and charged the court with acting towards him with a premise of personal bitterness or hatred. Hallinan stated that Judge Harris was and is a personal friend of Eugene. And that's the story of Eugene I told you about, who was an enemy of Hallinan. And Harris had taken Eugene's part in a controversy between them and took Hallinan into the privacy of his chambers and tried to get him to give up his case. He also goes on from there to explain all the bias. And so this is what's put before the court. And so the question then that we have to ask is, based on that set of facts, could a reasonable observer think that the judge was biased based on those facts? And so we have to look at, were the facts speculative or were they concrete? Here the facts were concrete. There's a pretty detailed story about Eugene, Judge Harris, Vince Hallinan, this enmity and bitterness between Harris and Hallinan, and how Harris had engaged in some conduct that was perhaps improper at the time, and that perhaps shows that he had a personal disfavor towards Hallinan. These facts also came from an extrajudicial source, which remember is very, very important. And so this component, at least, of the charge wasn't hinging on how the conduct of the trial was unfolding. As we turn to the next slide now, we have to ask, what should Judge Harris have done? And there's a picture of Judge Harris. And so what we have to know by background is that the disqualification charge had two components to it. It had the component about the Eugene story, but Hallinan also charged that the judge was biased against him because of the judge's improper curtailment of the defense conspiracy theory and the improper curtailment of his cross-examination of the witness. And so both of those were the factual predicates given to charge the judge with bias. What should the judge have done? Well, the extra record story is one that I think genuinely and fairly could raise real questions about the judge's partiality. And so based on that extrajudicial set of facts and the story of the personal history and bitterness and Judge Harris's comment that I'm going to get you, the judge should have disqualified himself. Now, what about the challenge to the judge based on the judge's ruling in the case? Those are not extrajudicial facts, and those are simply a lawyer disagreeing with a judge. And as charged an environment as it was about communism and this conspiracy and this long-standing story of how the government agents and the FBI and private industry had been out to get Bridges, and it's very heated as it is, for Vince Hallinan coming in as a pro bono lawyer into this immigration deportation battle to represent Harry Bridges, he ignored the judge's orders and rulings and did justifiably end up in trouble as a result of that. And so really, he crossed his ethical boundaries in terms of zealous advocacy to one of disrespecting the court and flouting the court rules. And that's not a basis to charge disqualification. So what did the judge do? Well, here you have Hallinan talking about how, and this is another copy of the transcript, he's going to swear out an affidavit about all the bias in more detail. And the judge tells him, you will not file the affidavit. Hallinan says, we will try it out for sure. I'm going to put the facts out. We're going to have a hearing on this. And the judge tells him, you will not file any affidavit before me. And Hallinan then tells the judge, well, I don't care what you said. I am going to file it, as you see on the next slide here. And the court says it'll be stricken from the file. The result, motion to disqualify, denied. And on the next slide, you can see just a fascinating sort of just copy of part of the transcript. The judge was clearly so upset that he just started ruminating and talking about himself in the first person, saying that I can't harbor malice. I could never do those things that Hallinan brought in here. It's outrageous. It kind of reeks of Shakespeare's "Thou doth protest too loudly." And so as we turn to the next slide, what the judge then did was, having denied the disqualification motion because of Hallinan's behavior, the judge said, you're going to jail for 6 months for contempt of court. And what happened is Hallinan, after the pandemonium broke out that I told you about, the judge eventually stayed the sentence, allowed him to continue on in the trial for the duration of the trial. It became the longest federal court trial in San Francisco court history at the time, and it resulted in Harry Bridges being convicted with an order of deportation then following that, and a prison sentence, obviously. And the entire case became incredibly difficult for the defense for the 3 months after that third day of trial I told you about. On the next slide, you can just quickly see, after the jury issued its verdict, the judge, in this moment of zeal, tells the jury that you have finally found the golden truth shimmering in the fiery crucibles of this trial. That's down at the bottom of that slide. A very odd statement for a judge, again showing the judge really had transcended the bounds of neutrality in terms of how he was behaving. So the ethics question then is, what should the lawyer have done? What should Vince Hallinan have done? And did he trip his ethical obligations? And this is a very, very difficult question. It's difficult when you're in a charged environment that's maybe a little unfamiliar. There's a heated background and emotion and anxiety and all of that. But here we have Hallinan having gone too far and tripped his ethical obligations to the court in terms of not respecting the court's orders. I mean, the courts issue evidentiary rulings for us all the time. We may disagree. If you don't want to take up an immediate writ, you just have to deal with it and deal with the issue on appeal ultimately. And that's the nature of the system that the respect of law demands. And so in that sense, he went too far. The judge also went too far in refusing to recuse himself based on the history and the personal bitterness. And the result was that it was a brutal trial with more incredible drama. And as you go to the next slide, you can see our postscript to this ethics dilemma. Bridges was convicted, the Ninth Circuit affirmed, but even in affirming, they noted Judge Harris's improper behavior. And again, the case went up to the U.S. Supreme Court for the second time, and for the second time, the Supreme Court reversed. And so again, by one vote. And so Harry Bridges managed to survive, but Vince Hallinan spent 6 months in freezing Puget Sound in a prison for his challenge to the judge's supremacy. And even then, the government began a fourth deportation trial. You don't need to buy my book that details the whole history of all these trials to know what happened in that fourth trial, but you do have to wait to the end of this presentation when I'll tell you. And so this theme in the book, in the story of Harry Bridges that deals with pro bono lawyers and these ethics questions, really brings us now to the contemporary immigration system. And so on the next slide, you can see it's the story of pop stars and rice farmers and the question of, in court systems, do we demand that cases be decided on their merits? And so I have these two pictures because they both come from actual cases I've litigated. The first one is a copyright case for one of my celebrity photo clients who got a photograph of Katy Perry in her bikini in the Bahamas, and it was a really popular photo, and it was infringed by loads of websites because everyone wanted to see Katy Perry in her bikini before her next concert. And so we filed a copyright infringement lawsuit against some infringers. And that case, what unfolded was a hearing was set and I didn't show up at the hearing. Countering mistake, my responsibility, just didn't show up. Case was ordered dismissed and I got an order from the court. And when that order came, I was upset, but I wasn't really freaked out because I knew I'd made a mistake. The court will reinstate the case. And I knew that because, as you see on the next slide, we have rules in our federal and state courts that require judgments be done only in the most serious and drastic of circumstances. And so default judgments should only be extreme. A case should be wherever possible decided on the merits. And the emphatic policy of the law as written in our codes and our rule books is that we look with disfavor on those who try to take advantage of mistakes or neglect. And those are some quotes that come from the California Supreme Court and the federal appellate courts, the Ninth Circuit. And this is because we want fair results, no technicalities, and everyone to have their day in court. And so ultimately for me in the copyright case, I knew I'd explain the mistake, I'd fall on the sword, and the court would reinstate the case, and my client's property right in its photograph wouldn't be lost. And as of course it unfolded, that's the road I went down. And the court reinstated the case, I apologized, and the federal judge was great and put the case back on track. Now, at the very same time, coincidentally, I was litigating that issue, I took on the case for a rice farmer from China who had been involved in a labor protest. And his case went to the immigration courts. And as you see on the next slide, we're going to look at what happens in immigration courts when people miss hearings. And there, what happened is he showed up for his hearing at 11 in the morning. And he had been told by a translator who the lawyer had hired to be there at 11. And so he got there at 11 and he sat in the courtroom for a couple hours, waited, the case is ended, and he went up to the clerk, didn't speak much English, to say, what about my case? You didn't call me. And the clerk looked at the paper and said, your case was at 9 a.m. You weren't here, you were ordered deported in your absence, in absentia order of deportation. And he waved his paper and the clerk said, too bad. The judge was actually even on the bench at the time and the judge just kind of walked off the bench, so be it. So he then went back and got a lawyer, filed a motion to reopen to explain that I'd had a translator who gave a translation mistake. The translator gave a document under penalty of perjury saying, I translated it wrong, I'm sorry. He really was there. And government lawyers objected and it became a massive argument. And as it turns out in the immigration court system, there's no similar policy to the one we have for the photograph of Katy Perry or for your bicycle if it's a fight over who owns a bicycle. And so the court said, yeah, too bad. You should have been here on time. You lose. So he's ordered deported. And so I took that case then on appeal up to the Ninth Circuit as a pro bono lawyer, and it's a very troubling, difficult case. And so we litigated that one aggressively in the Ninth Circuit, and ultimately we received a panel that was not the most favorable panel, and we lost. And so he was ordered deported, ultimately. And so this then gets at some of the ethics questions we're going to look about in our current system. As you go to the next slide, we have to ask ourselves, who are the judges in our immigration court system, and why is this court system so different? And as you peel back layers to the onion, here are some very fascinating facts that most people aren't aware of. The immigration court system is controlled by the executive branch of the government, the same executive branch that pays the prosecutors to deport people in the court system. And so the court system is not controlled by our neutral, co-equal branch of government, the Article 3 judicial branch. If we peel back another layer of the onion to start getting at questions about who are the judges, what we learn is that unlike our state and federal judges, there's no vetting process. You get letters as a lawyer, obviously, from your state bar all the time saying so-and-so wants to be a state court judge or a federal court judge. What do you think? How's their temperament, their wisdom, their personality, all those types of things. And then they go through committees and screening committees at the local bar, the state level. They get hauled before Congress, before a hearing on the federal side. And this is done because we want sunlight to pour through the people who are going to be our judges to figure out, their biases, their politics, how they think, decide, and feel about a variety of issues, so that we can know as much as possible about these people when they become judges, then deciding the fate of people and the fate of business in this country. No such process for immigration court judges. It's simply a political appointee, so you apply and you get hired. The next fascinating fact is that you only need 7 years experience as a lawyer to be an immigration court judge. If you pause and consider that to be a small claims court judge, for example, in California, you need at least 10 years of legal experience. But to be an immigration court judge, you only need 7 years. And then if the judiciary is too liberal, it can simply be fired. And there's a famous example in the early 2000s when President Bush was elected and John Ashcroft was then appointed as Attorney General. There was what's known as the Great Purge, where many immigration judges who were perceived as liberal were simply fired and replaced. The other fascinating fact to look at, and this data comes from my book called Show Trials, which studied the difference between our federal and state courts on the one hand and our immigration courts. The other piece of data is that when you look at our district court judges, for example, almost 50% of them have some sort of prior judicial experience. Maybe they were on a superior court, a municipal court, an administrative court even, but they've had some significant experience deciding cases and weighing the credibility of witnesses and the fate of people in this sort of very difficult Solemnic process. Only less than 10% of immigration judges have had any prior judicial experience. I mean, it's a five-fold difference. And so this next slide is really interesting because you can look at the percent of judges with the noted years of experience. And so the light gray slide are immigration judges and the dark gray slide are the district court judges. And if you just look at what percentage of the federal judiciary, for example, has less than 15 years experience as a lawyer before being a judge, it's like 6-7%. And very few people get on the federal bench with less than 15 years experience. This was of all the current sitting judges as of around 2012. Almost 40%, though, of immigration judges have had less than 15 years. And now these numbers, what's so interesting, as you get to greater years of experience, further down the years axis on this slide, the numbers invert. So of our federal judiciary, for example, those who become judges having had at least 25 years litigation experience, dealing with questions of evidence, trials, juries, credibility of witnesses, etc., all the stuff we deal with as practitioners. There, almost 40% of our district court judges have had at least 25 years practicing experience, whereas barely over 10% of the immigration judges have had that much litigation experience. And so this data in this slide simply shows that in the immigration court system, at least, there's a vast difference between the judges. And that's the system that as a pro bono lawyer you're stepping into when you're having your fights over these contentious cases, over political asylum cases or whatnot. The next slide we can look at now talks about the judges, and this is just some reversal rate data. And so when you look at data between 2000 and 2010, the immigration judges on their decisions going up to the Ninth Circuit, for example, Court of Appeals, were reversed 2 times more than our district judges are reversed coming up to the same courts. And in some years it was 4 times more. And those are staggering differences in terms of reversal rates of, from the Ninth Circuit looking on the decisions below. The next aspect to our contemporary immigration system that we can get out on the next slide is this question about a right to a lawyer. 60% of the people in the immigration court system are pro se. Only 40% end up with counsel. And as it turns out, there's no right to a state-appointed lawyer to defend them in a deportation proceeding. And this is irrespective of whether the alien in the deportation proceeding is detained or not detained. It's irrespective of whether they have a political asylum case claiming that they could be killed or tortured if returned to a foreign land. Regardless of the risk of harm to their life or liberty at stake, there's no right to counsel. The next kind of aspect to our system that we need to think about is if you prevail, is there a right to fees? And it turns out there's no right to fees in immigration court cases for those who prevail in the court cases. And of course, the question this gets at is the carrot stick. There's this sort of, incentive if you have a fee right to have lawyers enter the area and litigate because they could be remunerated with fees ultimately, but it doesn't exist in the immigration court system. So then when you look at the lawyers even, it turns out on this comparable data in that 10-year period in front of the Ninth Circuit that immigration lawyers were sanctioned 10 times more than non-immigration lawyers appearing before the Ninth Circuit. That's a staggering disconnect in terms of the nature of what's then going on in the lawyering system representing these people. And the flip side, of course, that's so interesting is that government lawyers actually cannot be sanctioned in the system, but private lawyers can be. So our next slide, as you see, is entitled Mediation. And what we're going to look at here is the difference between the immigration court system and our traditional court systems with respect to mediation. Of course, what is mediation? It's not a current creation of our modern federal or state courts. It actually has ancient lineage going back to biblical times, and the ancients wrote about mediation as a means of dispute resolution. The idea that you would bring in a leader or an elder from the group or the tribe, so to speak, who would sit and listen to 2 different sides and would figure out some sort of a resolution that would be a resolution that everyone buys into, right? As opposed to a decision maker saying one person wins, one person loses, where everyone leaves then, or some people leave aggrieved and some leave feeling that they're great victors. This idea is to find a resolution that everyone can live with by means of dialogue, discussion, discourse. And so it was used by our ancients, and it's used in our court systems today to solve problems. And it's even used, obviously, in international diplomacy. I mean, the most famous example, of course, being things such as the Camp David, Accords and the shuttle diplomacy that was occurring. And, the shuttle diplomacy that occurred at Camp David really is just mediation, where President Clinton and President Carter and prior presidents, Reagan, had been mediators, in effect, going back and forth between 2 different groups to try to find resolution. So, this idea of mediation exists in our civil court system, but does it exist in the immigration court system? And so here too, I'm going to give you an example from one of my real world cases in the immigration court system, a pro bono appeal that I was fighting. This case involves a woman from Armenia who, during the collapse of the Soviet Union, was living in Armenia with her husband and her children, and then there was ethnic warring that occurred as the political powers of the different groups changed, and the religious geographic landscape was changing as this sort of implosion was occurring in the late 80s, early 90s. And so she was living in her house and was of the disfavored religious group and found her home literally taken over by people who forced her to live then on her own balcony for a while before she actually had to leave the house. Her children managed to escape and get to the United States, and her daughter even then got married and secured political asylum or status by virtue of marriage here, and the husband had secured asylum and was living in America. And so now she had been through that experience where she was forced to live on her balcony because of her religious affiliation. She then couldn't find other places to live because of her religious affiliation. Her husband and her then, were bouncing around trying to survive. The husband eventually died of illness that wasn't treated. And so this elderly woman managed to get to the United States. And she then secured a pro bono lawyer in immigration court. It wasn't me, but it was someone else who asked the immigration judge to give her political asylum. And so put on the case. And what was very interesting about the case is that her daughter was a citizen and could have sponsored the mother to become a citizen. And in fact, the daughter had filed a citizenship application for the mother and had sponsored her. But then the daughter had withdrawn it. And what was very clear from the record, and it wasn't expressed per se, but it leapt off the page in terms of it being almost expressly stated, is that the daughter was pressured by the daughter's husband to terminate the application for the mother. There was some inter-family fight or whatnot. And so the daughter simply couldn't sponsor her mother anymore for fear of punishment or retribution from her husband. And so she had to abandon her mother's application, but she did come and testify for her mother, and that sort of came out as part of the background story here to why this woman, who simply could be the beneficiary of her daughter and secure citizenship, or at least a green card and status, was instead in asylum proceedings. And so the asylum case was put on, the immigration judge heard the evidence, the immigration judge concluded that she told the truth in her testimony, that she had been subjected to that torture and persecution because of her religious affiliation. But the immigration judge concluded, that was about 10 years ago. The landscape has changed and shifted in the last 10 years. And so, there'll be no harm to you if you get sent back to Armenia. And the woman now is in her, mid-70s. And the immigration judge says, you'll be fine. You'll be able to go back to Armenia and you'll survive. You won't be tortured anymore because the groups that were harassing you before, they've moved on. They're not in power anymore. So, effectively, no harm, no foul. And so, even though believed everything she said, ordered her deported because it was of that conclusion. And so she took her appeal up to the Board of Immigration Appeals, which is the executive arm of the immigration court system under the executive branch. And the appellate immigration judges looked at it and concluded, yep, no problem, you can be deported. And so then she filed her appeal to the Ninth Circuit. And this is the one and only chance that she had to get her case heard by the Ninth Circuit Court of Appeals, a neutral Article III court. And that's where I took her case as a pro bono lawyer. And did the briefing for the court. The government did their opposition briefing. And I showed up at oral argument. And at oral argument, it was a spirited, heated debate about whether she would, face persecution and torture if she was to be sent back. And one of the Ninth Circuit judges asked the government lawyer a very, very penetrating question. The judge said, this case doesn't make any sense to me. This woman's 75 years old. Her daughter's here as a citizen. She clearly could have got citizenship, but for some unforeseen circumstance that we kind of know what happened. But the judge said, why do you want this 75-year-old ill woman who had medical issues too that we had now documented in the record? Why do you want to deport her? What's the big deal? Why can't you figure out a way to let her stay? And what the judge then said is, will you go to mediation? And the government lawyer said, no, we don't mediate these cases. We're unwilling to mediate them. I have no authority to go to mediation. The judge actually got pretty upset and said, this is what I hear all the time in these immigration appeals when we ask you to go to mediation. And the judge then said, all right, well, that's enough of your argument. And the judge said to me, you have another minute. Do you have anything to say? And so I got up and said, mediation? Absolutely, we want mediation. And pushed the court to order us to go to a mediation before a circuit court mediator, to see if we could find a resolution. And the court then, it was very interesting. The court, struggling with a case that was probably difficult legally on the merits, given some of the legal issues and the fact pattern. It just wasn't an easy case necessarily, but was a sympathetic case. We received a court order to go to mediation. And so what I thought was then going to be a sort of a 2-hour event where we went to mediation, in fact became another year of near bi-monthly mediations with me and my client, a circuit mediator, and the government lawyer. And the first 2 or 3 of them, it was fascinating. The government's position basically was, we don't mediate immigration cases. We just want a decision. We refuse to talk. And this went on and on and on. But eventually, it was really interesting. Eventually, through this process, there was enough diplomacy, pressure, whatever you call it. I don't know what happened behind the scenes between the mediators and the government, but eventually the government said, okay, fine, we're willing to do something. And so this then became another set of negotiations. And after literally a year, we reached a compromise resolution whereby our client was entitled to stay, but would never be able to receive benefits or any other kind of any social welfare or anything like that, but was entitled to stay in some sort of twilight status whereby she wasn't a citizen or a green card holder, but nor was she subject to deportation. And this was many, many years ago before the new programs had been created for voluntary departure and the like. And so it was ultimately an example of, how mediation, if demanded and insisted, can be used to find a compromise resolution where everyone gets something even though nobody gets everything. And so the government didn't get her deported to Armenia, but at the same time the government didn't get her becoming a citizen and collecting benefits and whatnot. And if those were their concerns, they got something. And from my side, on the litigation side, of course, I didn't receive the ultimate version of justice I wanted for my client, to win and become a green card holder and then a citizen and to be able to have access to everything. But I did receive a semblance of justice. She was able to stay as a 75-year-old woman and live near her daughter and her grandchildren here in the United States and not be sent back alone to a foreign country, and could live out her life in relative safety with family nearby. And so it's a perfect example of how mediation can work and can find solutions to human problems. But as it turns out, it's not demanded in immigration court. That was just the miracle of extreme pressure brought to bear. And I've had many, many other cases where I asked the government to mediate, they refuse, where the courts have asked them, they refuse, and nothing happens. You just can't get a resolution. And so it becomes an all or nothing proposition in litigation where someone is going to win and someone's going to lose, and the stakes are really high, and you're forced then to fight on, both as counsel and as government counsel, to ultimate victory or ultimate loss. What's so interesting when you think about this in terms of the implications for these two court systems is that in our property court systems, where we fight about ownership of a bicycle or the ownership of the copyright to photographs of pop stars in bikinis or whatever it is that we're fighting about, mediation exists. And in fact, mediation is basically demanded. And so, a typical example would be one of my cases in federal court, one of my intellectual property cases. I litigate along, and at the first scheduling conference, normally the court says what kind of mediation you're going to go to. Are you going to go to a private mediator? Are you going to go to use a free neutral for a couple of hours? Or do you even, in the Central District of California at least, you get asked if you want to use one of the magistrate judges. And there are several magistrate judges who are renowned settlement judges. Judge Gandhi, for example, in the Central District, an incredible settlement judge. And this gets ordered, and you have to actually, as part of the case management order in the case, you have to figure out an agreement between you and the other side as to what form of mediation you're going to use. And so we do this in our cases all the time, and the judges demand it. And I've had cases where we have agreed to go before a mediator at some point, but we've never made it, right? Everyone's too entrenched in their litigation positions, the clients are too far apart, and no one has pushed for mediation. And so the case has chugged along, and I even had one trade dress dispute where we showed up at the pretrial conference, having worked up the case. We were basically ready for trial in a few weeks, and everything had been done, and the court said, "You've not been to mediation, I see. Why not?" And we said, there's no way to settle it. We've had talks, among counsel. We've tried to come up with a resolution. We can't resolve it. Everyone's ready for trial, Judge. Other side says the same thing. We're ready for trial, Judge. We can't settle it. The judge says, you're not going to trial. You're going to go settle the case, or you're going to try to settle the case before you go to trial. And we got ordered by the court to get before the magistrate judge with our clients immediately. And we then get sent down to mediation, and the clients have to attend, and the magistrate judge goes to work, and lo and behold, the case settles. So the point being, it's a process that works and is of ancient lineage and is great for solving human disputes, but it doesn't exist in immigration court. And that is one of the complexities to this system. So now as we turn to the next slide, we're going to talk about the right to appeal. And what you see on this slide is, the appellate system we're going to talk about. So what you see on this slide is that there is a right to appeal in our federal courts. And this right to appeal exists for all property disputes. And it's not just our federal courts, it's our state courts also. And the reason for this is that it's basically a basic right. The idea that we may go to trial and lose and not have a right to appeal is unheard of. And in fact, the appellate system is so robust and there is such an ingrained right to appeal that for a certain subset of our property rights, our patents, there's a specialized appellate court system that has been created, and that's the Federal Circuit Court of Appeals in Washington, D.C. That court system exists to decide only patent disputes, basically. It's a singular court system for all patent cases. And the reason for that is because patents are so important to us as a nation, as a people, that we want to have uniformity in the appellate decision-making process on patents, and we've created a singular court appellate system for them. So, what about in our immigration court system? When the cases are done in immigration court, can you always go and appeal to the Ninth Circuit or the Second Circuit or the Fifth Circuit, depending upon where you live? And the answer to that is no. In many of the cases you can, but there's a subset of removal and deportation, immigration cases, for which the decision of the executive branch judge is final and literally unreviewable by the neutral Article III courts. And so that's the decisions that are based on extreme hardship. So when you have folks who've been here for many, many years, they can show good moral character, and they don't qualify for asylum, but they qualify, prima facie for cancellation of removal. For example, they've been here for 20 years, they're good moral character, good citizens, they've paid a whole variety of taxes, they have qualifying relatives such as US-born children, and they have to show hardship to the kids. And so you have cases where people will put on evidence before the immigration court that they have citizen children, and deportation of the family would provide great hardship on the kids. For example, the kids may have medical conditions for which they can only get medical treatment here in the States, and they couldn't get it back in Guatemala or wherever they're being deported to. And the immigration court's decision as to whether that fact pattern amounts to the requisite level of hardship to suspend the deportation, to cancel the removal in current verbiage, that decision, literally unreviewable by the neutral federal courts of appeal. And that was a product of some laws passed in the mid-1990s. Illegal Immigration Reform Act and the Anti-Terrorism Effective Death Penalty Act also took a bite at the immigration appellate right. And so there we have an example of how this right to appeal, which is basic and part of our court system for all property rights and all constitutional civil liberties, civil rights, criminal cases in our state and federal court systems, doesn't exist in our immigration court system. And so this then helps get at this funnel that we're talking about. This is the reality of the difference between these two court systems, and what we're getting to is a funnel here. And so here this reality is that if you look at the chart, we can look at what happens in our sort of property criminal courts, so to speak, and our immigration courts, and the various rights that exist. And these rights include, the right to neutral Article III courts. Do you have a transparent vetting process? Do you have low reversal rates and a lot of prior experience? Is there a right to appeal all the time? Is there a right to a lawyer? Do you have the right to legal fees? Do you have the right to even attend mediation to try to resolve case? And is there this general right that we started with to have cases decided on the merits at all costs, really, to make sure that we get to the bottom of the truth? And the slide is staggering and jarring when you look at it in terms of the disconnect between the two court systems. And so, on our next slide, we have a funnel, because what we're getting to here is what this funnels down to for pro bono lawyers. And so as we go forward, we see what it funnels to is that there's a staggering need for pro bono lawyers, particularly in the immigration court system, and this then instantly triggers ethics questions. And this picture we have, it's just a fascinating aside. It's a picture of Lady Justice, and this comes from, and this is just a quick aside, but it comes from the Robert F. Kennedy Memorial Hall of Justice, the Department of Justice, and it's really an iconic statue of Lady Justice, with her arms up in the air and a robe covering one of her breasts. And what's particularly interesting about it is, at the same time that great purge occurred that I told you about, Attorney General John Ashcroft didn't like the statue and wanted her shrouded because her breast was showing. And that was ultimately denied, and he wasn't allowed to shroud her. But it was sort of metaphorical for the idea of shrouding of justice that's occurring in that system, I thought. And so this gets us to the ethics question we're going to talk about first in terms of pro bono lawyering in the immigration court system, and that is from ABA Model Rule 6.1. The ABA Model Rule states that every lawyer has a professional responsibility to provide legal services to those unable to pay. A lawyer should aspire to render at least 50 hours of pro bono publico legal services per year. In fulfilling this responsibility, the lawyer should A, provide a substantial majority of the 50 hours of legal services without fee or expectation of fee to, number one, persons of limited means, or number two, charitable, religious, civic, community, governmental, and educational organizations in matters which are designed primarily to address the needs of persons of limited means. So this ABA Model Rule 6.1 raises fascinating questions we see on our next slide about pro bono reporting requirements and the ethics-based rules that encourage pro bono work. And what's particularly interesting here is that several states have voluntary reporting requirements for pro bono work. For example, Maryland's Rule 19-306.1, Indiana has a rule, Mississippi, Hawaii, Florida, Nevada, New Mexico, New York, and even 13 other states have voluntary reporting requirements. And you can see all of those at that link there to the American Bar Association's website that lists all the different states that have voluntary reporting requirements. Now, those are not mandatory, you must do pro bono work or else, but they are mandatory reporting requirements that you are required to report if you've done 50 hours, 100 hours, or even 0 hours. However much you've done, or even if you've done none, you must report your status on the provision of pro bono work. Particularly interesting for those of you in California, however, as you see on the next slide, is that California, on the other hand, has no such requirement. And it's a fascinating then question to raise. For those of you in California, for those of you in states without a voluntary reporting requirement and without a mandatory rule such as the ABA recommends and proposes for the profession, for this profession, this wonderful profession that we're in, the fascinating question to ask about is what problems in our justice system exist. And when we look at the immigration court system, you think about the access to justice, about fair justice, about ensuring cases are being decided appropriately, that some people lose for sure, but did they lose having had a full hearing? Some people win, that's great, but did they have a full and fair hearing? These questions get to the root then of the need for pro bono lawyer intervention. And this is critical really to enable cases to be adjudicated on their merits. And that gets to the policy that is really a sacrosanct policy in all of our state and federal courts, which is we want, if at all possible, to always have cases decided on their merits so that when people win and when people lose, at least they can know they had a fair shake, fair bite at the apple, and the chips may fall where they do, and that's okay. But we've had our day in court, right? And that full and fair hearing to have evidence being, admitted and assessed and considered so that whether you win or lose, you had your day in court is really, really critical. And the immigration court system, of course, is a fantastic petri dish to kind of look at these questions to get at the need for pro bono lawyers and the need to consider adoption of these mandatory pro bono reporting requirement rules as part of our ethical obligation of lawyers. And so for lawyers in California, for example, or other states that don't have them, you can demand that the state bar consider adopting such a rule. And every once in a while, these rules get floated by our state bar organizations for consideration. And it's something that you can write a letter to your representatives in the state bar and demand that voluntary or even mandatory reporting requirements be adopted. And so I certainly don't believe that it's certainly not for me to preach about which way it should be. I think it's a debatable issue, and there have been vigorous debates on both sides of it. And there are fantastic debates, really, that are worth thinking about and worth pondering so that you can take a position yourself on where you stand on these ethics questions. And whichever side of the line you stand on, I think it makes sense to let your state bar know so that more information and data can be collected. And so here you have sort of some of the counter arguments to the idea that it be a requirement. And they're legitimate arguments, such as that compulsory pro bono is effectively a contradiction, and that you also convert what are legitimately noble efforts of the profession that should be respected and rewarded and seen as being generous and kind that people do, instead of those being part of the noble provision of services of a profession, the service profession, it becomes a chore, and that undervalues and ultimately undermines the service. And the flip side, of course, is that, do you provide more access to more justice for more people? And even that raises questions about should you. So this fascinating sort of policy debate that exists is alive, it's large in the ethics area, and it's something to think about. Now, on the next slide you see, if you do take a pro bono case, we have to get to the questions about what are your ethical obligations to your client? What are the professional responsibility rules related to competency? And the rules of competency and diligence that apply to all of your efforts as a litigator or a transactional lawyer for your client apply fully and across the board to your pro bono clients. And so we'll use California's rule as the exemplary rule, although it's the same in all basic jurisdictions. Rule 3-110 in California says you cannot recklessly fail to perform with competence. And so this is a particularly important rule, because what happens very often when you talk to pro bono lawyers is they feel, well, I'm providing charitable work, I'm helping, I'll do my best. If it doesn't work out, well, I did my best. A free lawyer not doing a great job is better than no lawyer. That thinking that can undermine the idea of providing charitable help and assistance is a fatal mindset for you as a lawyer to take. Your ethical obligations to the pro bono client are no different to the Fortune 100 corporate client. You have to perform competently and not make any reckless mistakes. And so what's as an important practice pointer here, for example, is regardless of what area of law you're going into, you need to brush up on that area of law. And there's normally programs that state bar organizations or your local bar provide in these areas. And so the immigration one, for example, if you have never appeared in immigration court or done an immigration appeal, there's fantastic resources. For example, the Immigration Manual on the Ninth Circuit's website is a great manual that you can go to, that you can read, you can study to make sure you don't trip Rule 3-110. The other important rule, and this is a particularly important rule if you are going to dabble in the immigration arena, is Rule 3-210. And this is the rule that is, for us as civil lawyers, it rarely comes up, but it's you cannot advise a violation of the law. Civil lawyers don't kind of run around in that world all that much. You criminal lawyers probably deal with this rule all the time. But if you're a pro bono lawyer in immigration court, this becomes an important rule, and it comes to fruition at kind of at the end of a case where you have, for example, represented an immigrant in immigration court proceedings or on appeal up to the Ninth Circuit. You've tried to secure asylum, and you lose. And you will lose these cases. Some win, some you win, some you lose, but you lose. And the person now is ordered deported. And maybe you try a cert petition that gets denied, and that is the end of the line. And so the question that I've been asked several times by my clients is, what do I do now? Can I just go into hiding? Can I disappear? Where do I hide? These types of questions. And you as a lawyer, it's very emotional. You're very, very sad. You fought this case for a long time. You really feel that this person is going to be killed if returned to a foreign country, that something terrible is going to happen, they may be tortured. And you're being asked now questions that start flirting with advising violations of the law, and you have to maintain your guard. These are the ethical rules to maintain the integrity of you as a lawyer and us as a profession, and realize that even though you feel it unjust and wrong, you can't advise a violation of the law. And so the advice that you have to give the client is you have to follow the law. You've been ordered deported. It becomes a criminal penalty if you violate that duty, and your obligation is to comply with the court order and leave. And they're very, very awkward conversations, obviously, to have with people because they're tragic and heartbreaking, and there's nothing more you can really say. But the conversations have to end with you as a lawyer cognizant that you do not advise a violation of the law and encourage someone to ignore the order and disappear and hide or something like that. So this gets to our conclusions on this presentation. At least in the context of immigration, it's a charged arena. The politics are high, really, in all administrations and at all times, but certainly in the late 2017 and later time period, it's particularly charged, and so it's a great petri dish to study these ethics questions. When we loop back to the disqualification issues, remember you have to tread very carefully in charging disqualification, and you have to proceed cognizant of your ethics obligations. When you're doing pro bono work, get training. Don't make a mistake and trip your obligations to your clients. And then ultimately decide for yourself whether you think states should have mandatory reporting requirements or even mandatory requirements, and get involved in the debate and offer your side. And now, as I promised, as for Harry Bridges, you don't have to buy the book, but there's a copy of the cover there if you're interested. But what happened to him? There was a fourth civil trial that he was put before. And this trial, interestingly, was transferred from Judge Harris to a different judge. And the government put on a roster of witnesses saying that Harry Bridges had been at a variety of Communist Party events and that he was a member. Harry Bridges this time had a renowned lawyer, Telford Taylor, one of the Nuremberg war prosecutors, defend him. And that's a footnote to a lesson. If you too zealously defend your client and upset the judge, you may also upset your client and not get hired for the fourth case in this case. And so in any event, Vince Hallinan wasn't there for this case. Telford Taylor was. The trial was in San Francisco. It was a civil denaturalization trial, and it was the fourth trial in this 20-year span of trials against Harry Bridges. And ultimately, the federal district court judge heard the evidence and concluded that the government had, for the fourth time, put on a new roster of perjuring witnesses who had lied and been caught in cross-examination. Really some incredible, cunning cross-examination traps that were laid by Telford Taylor. It's just that sort of magical Perry Mason type stuff to read. And it's all detailed in the book. And Harry Bridges ultimately prevailed. The judge ordered that the proceedings needed to come to an end. They'd gone on too long, and that the government's conduct had been simply abusive of due process in this man. And drew curtains closed on the trials. And Harry Bridges, then, this immigrant from Australia who rose to prominence running the union, lived out his life in the United States running the union into his late 70s. Thank you for listening to today's presentation.